So as I've said, if you do get kicked out for any reason, you should be able to get yourself back in again. Any problems as well, please flag up on the chat. That is being monitored today. So we've got quite a few of our team on today who will be keeping an eye on the chat function as well. So welcome to the HR Exchange. Today we are doing settlement agreements and safe exits. You will hear from my voice, I am a big croaky today, and you'll be pleased to know I'm not presenting most of this, so you don't have to listen to me croaking on at you. But for those that don't know me, my name's Lindsay Gamester. I am an employment solicitor here at Bhayani Law. I'm also one of the directors and head up our employment team. Can I just say as well, thank you so much for booking onto the HR Exchange. We're always really grateful and often surprised with how many bookings we do get on these. Granted, we get a big drop off, hence why everyone does, we start phoning around just to make sure. But no, it's great to see some familiar faces on here, but also some new ones as well. So a little bit about us. If you don't know us, so we are a firm. We're a solicitors firm. Our head office is in Sheffield, but we have offices now in Doncaster, Barnsley, Leeds, Leicester. We are spreading out across the country. So we are not just Yorkshire now. A lot of our clients are actually based outside Yorkshire too, so which is very exciting. As I said, we are a solicitors firm, but we focus solely on HR and employment law. We cover everything from your from recruitment, which we now do, through to contracts, handbooks, dismissals. We do your 2Ps, your restructures, unfortunately redundancies these days are getting more common. We're starting to see a spike again with the redundancies. Employment tribunal claims, we bring them, we defend them, and we also do settlement agreements, which is what we're here to talk to you about today. I do feel one of the advantages of working for both businesses and for employees directly is that we see the whole range, and particularly when it comes with settlement agreements, we draft them, but we advise on them. So we know what we're looking for. Yeah, we can pitch the argument from both sides. So yeah, in terms of, like I say, our offering, we're a one-stop shop for all your employment law needs. And particularly we have our watertight package, which is our HR support package. There are some of our watertight clients on today, so thank you very much for joining. But if you are interested in our watertight package and receiving HR support from our amazing advisors, then get in touch. There's a slide at the end as well with a bit more information. So we are an award-winning firm. We're proud of what we achieved. And yeah, we work hard at what we do. We're a friendly bunch. If you do know us, know that we're quite social. So again, at the end of this webinar, we'll put details on of our upcoming events, one being our Christmas social, which has pretty much sold out. We're scrapping for the last few places. Basically, as people say they can't come, we can add a few more on. But yeah, we've got a really good year planned for next year in terms of HR exchanges, other training events, and our conference as well, which again, I'll tell you a little bit more about at the end. So as I said, we are a one-stop shop for all your employment law needs. That starts with recruitment, and in a moment I'll just introduce you to Blythe, who's one of our recruitment advisors. But as a client of ours, we want to be more than just reactive. We want to be proactive. We want to help sculpt and shape your business. We want your HR function to have meaning and to contribute to the growth of your firm. I know lots of people see HR as it's a non-profit making role, but it doesn't have to be. HR is all your people management needs, and if you don't manage your people properly, you are losing money in so many different ways. So ways that we can help you, first of all, we will look at compliance. So your basics, your contracts, your handbook, is everything in place? GDPR, but we will do all that for you. Then we'll start having a look at your culture, which is so important these days, because what we're finding is, particularly in the recruitment world, is that employees are more picky about where they're going. They want to work for a nice firm. They want to work for a firm that is flexible, understanding, is forward thinking. So the culture of your business and your core values are so important, particularly when you're recruiting, because that's the message you want to put across to candidates. We deal with your live issues. So yes, we do the firefighting for you as well. You phone up, you've got disciplinary issues, grievances, capability. We can give you advice as you go along, or we can parachute in and do it for you. And also particularly tribunal claims, which is more my area of expertise. We bring them, we defend them. You know, we know what we're doing in the tribunal, and we can make sure that you're getting the best outcome. First, and then we also move on to future workforce planning as well. So that is so important. If you're only thinking about the now, then tomorrow, next week, it's going to catch up on you. You need to be thinking further afield than, oh, I'll just deal with today. And we want to help you do that. We want your business to be around next week, next month, next year, years to come. Training and events, as I said, we have been working on an amazing program next year of training and events. So we're still running our HR exchanges. We've got our conference. We're going to have an annual conference coming up, which will be next April. It's going to be in person. We've got Kenwood Hall booked for this. And we've already got some amazing speakers lined up, as well as us delivering your annual employment law update. But particularly, there's going to be a focus on well-being. So provisionally at the moment, I've got speakers on menopause, domestic violence, a domestic violence advisor. So ways in which you can start sculpting your business and culture. And also we offer bespoke training, and we are shouting about this from the rooftops, but we are now Skillbank with a Skillbank approved provider, which means that you can get help towards the cost of any training that you would like from us. And it doesn't just have to be the training courses that we've got in Skillsbank. You could come to us and say, I want a more bespoke course for my managers. They need more leadership skills. They need help with investigation or grievance, or even some of your basic things. We can tailor a course just for them, and you can be covered by Skillsbank and get the majority of your fees paid, which is brilliant. We look at your health and safety. We look to see, would HR software benefit your business? And then there's the other things as well that we can help you with. As I've already mentioned, we can parachute in HR to help you with some immediate problems. They can do your investigations and your grievances, or they can just come and sort out your paperwork. We've also got a commercial solicitor who works alongside us that can look at things like shareholders agreements. We can deal with directors' disputes, and also business transfers as well. If you're looking at buying or selling part of your business or buying a business, please come and speak to us, because we can help you with that as well. And as I said, this cycle all starts with recruitment. So we do have our own recruitment company. I won't say anymore, because I'd like to introduce you to Blythe, who is one of our recruitment advisors, who can give you a little bit more information about how we do recruitment differently, and we do it right. So Blythe, if you can unmute yourself.
Yes, of course. Hello, everyone. As Lindsay said, I am Blythe. I am a recruitment advisor at Bhayani Recruitment. Just so you kind of get to know a little bit more about me and about Bhayani Recruitment and my colleagues. I started with my colleague Charlotte, who is our legal recruitment advisor, and I specialise in the HR and the office-based jobs. And we have both been here now for nearly a year, which has flown by. It has been a crazy year. It's been such a challenge, really, for both of us as well, because we're a small team. We can dedicate a lot of time to our clients and our candidates, but because we've never really done recruitment before actually working here, we come from legal backgrounds and from HR backgrounds, so it was completely new to us, and that's why it was a challenge. But I do believe that we've been able to get it right, definitely. So for those who don't already know, Bhayani Recruitment was originally set up to assist our clients in Bhayani HR Employment Law. When the J saw a gap in the employment cycle and realised, right, okay, yeah, I think it's time to set up a recruitment business now. And that's what we did. So we deal with the range of the vacancies, as you can see on the presentation. But in all honesty, no vacancies really off the table for us. We don't really say no to much at the moment. So if you have anything that's not seen on the screen, then we'd be more open to have a chat and just see how we can help assist you. obviously there's one thing that we do really believe in is the importance of having strong relationships with our clients and with our candidates. We want to get it done right, we want to do recruitment right, and we do believe that having strong relationships is the way forward for this, because it's such a saturated market and we want to stand out for this reason. And I believe we do. We understand the market, we understand that it's been quite a hard market this year, I know that myself, but just to make you feel more at ease if you're thinking of maybe looking into recruiting for your business, it's looking up. We've noticed that with our vacancies, more candidates are applying. Lindsay's correct, completely, candidates are being more picky because it's a candidate driven market. They can be picky, and that's why you as a business need to stand out, and we can also help with that as well. So if you want to have a chat about recruitment, if you're wanting us to swoop in and do the recruitment for you, then we are here for that as well. And one thing that we do find really important is we love to work with charities similar to our sister company, Bhayani HR and Employment Law. We give 10% of our profits go to charities. And also one thing to take into consideration as well is that I know Lindsay mentioned that there's quite a lot of our watertight clients on the presentation today. Just so you know, if you are a watertight client of ours, then you also get a 20% discount on our recruitment rates. So if you are currently recruiting and you're struggling and you wanted a bit of advice, or you're looking into doing so, then we'd be more than open to having a chat with you and see how we can support you.
Excellent, thank you, Blythe. Yeah, as I said, we've got a big commitment to charities particularly, and we love the fact that we can give back. But the 20% discount not only applies to our charities, our watertight clients, but any of our Bhayani Law clients as well. So it's a really good saving and discount. Right then, time to move on to why we all here. We wanted to talk about settlement agreements today because ultimately lots of businesses now are going to be facing some quite difficult decisions over the coming months. We've just had the new budget through, and ultimately it's grim for everyone. But we are seeing companies now that are struggling with the cost of living crisis. We've all got electricity bills, gas bills. It's getting colder. Can we afford to be running the offices? Have we got the same amount of work coming in? Do we have the right levels of staff, or staff in the right places? And sometimes settlement agreements are our only option in order to start reorganising, and may even be a precursor or an alternative to redundancies. So they're a really important part of what we do, because they are by far the safest way to dismiss. So I'd like to introduce you to Hannah, who is one of our employment lawyers, and she is going to take you through the world of settlement agreements. So Hannah, I'm going to hand you over the slides. You should now be able to move through the slides.
Thank you. Thank you very much. Yes, as Lindsay very kindly introduced me, my name's Hannah. I'm an employment lawyer at Bhayani Law, and I have been asked today to tell you a little bit more about settlement agreements, because we do think that they are, well, we've already seen the increase in the requirement for them. So we can talk you a little bit through them today, and hopefully this will help some of you out. So really, settlement agreements are often used to dismiss. Typically, to look for a reason to dismiss somebody, you're looking at the 5 fair reasons for dismissal. So they would be conduct, capability, redundancy, illegality, or some other substantial reason. Now, these are all very well and good if you have followed a fair process and you've gone through any of these processes to pursue a fair dismissal. That's great. But as we say to most of our clients, and if you have ever worked with me before, I've probably said it to you, there is no way that we can guarantee that they will not pursue any claim against you, even if you have done absolutely everything right. Obviously, we would always advise that you do everything right and you follow these fair processes. But unfortunately, if some people have just got a little bit of a bee in their bonnet about it, without a settlement agreement, that is the only way you can put a very firm full stop behind that dismissal and terminate somebody on those grounds. It also a settlement agreement may also reduce the length of time or the necessity for these full procedures when going through a capability dismissal, for example. That may take you a number of weeks, months more often than not. And so a settlement agreement may be a quicker an easier option for you to consider, and it's definitely worth considering before you go kind of headfirst into any of those 5 processes. I do know that I think our next HR exchange, or maybe the one after in the new year, goes into these reasons a lot more in depth in terms of dismissing outside of settlement agreements. So I won't go on with it too much, because I'm sure you'll all be eager to attend that HR exchange as well to learn a little bit more about those. So really, a settlement agreement itself, what is it? Some people know it as a compromise agreement. That's what it used to be called, and it can sometimes be referred to the same, but it is formally a settlement agreement. It is a legally binding contract which mutually terminates employment. I know some people can get really quite sensitive about it being a dismissal, or their employment has been terminated without their will. It is a mutually agreed agreement. I think in the news yesterday, you know, Cristiano Ronaldo, it was a mutual agreement that he was leaving Manchester United. Whether it was actually mutual in real life or not, I'm not sure, but that's the position and that's what they're sticking with, and that is also what a settlement agreement will state, that it is a mutual agreement. It is confidential, so both parties are held to very similar confidentiality clauses, which state that neither one of them can go and, you know, print something in the local paper or pop it all over Facebook. And they are very, very strict clauses within those agreements, and probably ones that more often than not, the ones that will be breached. But they give peace of mind to everybody that, you know, this isn't going to come out in the wash. It's not going to have major reputational damage for both parties, and ties it all up nicely and rather quietly. It does set out the payments due to the employee, generally with some form of compensation. So it will be, you know, we will pay you X sum of money if you will exit the business, not pursue any claims against us, and essentially go away quietly. That would be great. And it has to set those payments out, and the tax implications of those payments as well have to be explicitly stated. So that would all be very clear when reading the document. It does end all legal claims against the employer. Most, we can go through those later on, but yeah, all claims. If you think this has gone a bit south and it's not looking good, and I think they're rather litigious and they could come back and cause us a real headache, even though we've done our best throughout this process, we've done everything we should, this will ensure that they will not be able to pursue those claims against you in the employment tribunal. So it is definitely something that provides a lot of peace of mind for many of our clients when providing these agreements. And rather importantly, it cannot be used as evidence if offered correctly. So if there is any claim, you would not be considered to have been dismissed. It's not a dismissal letter. It's not something that says, you know, you stole thousands from the company and therefore we're sacking you and we're going to use this to evidence this to a judge. Because of those confidentiality clauses, because of the nature of the agreement, it is not going to be used as evidence, but it has to be offered correctly in order to have those protections. So why use a settlement agreement? As I say, it ends nearly all ongoing and potential legal claims. Again, it's that peace of mind for the employer. When moving forward, when this has all been dealt with, you can rest assured that, you know, it's not going to come back and bite you. It sets out a clear plan to the termination date. So it may be, we see them quite often, potentially with redundancies, that, you know, we've agreed it on this date, but your employment might not end till 3 months down the line, but we know exactly what's going to happen between then. There's going to be a clear handover. You're going to receive your notice in this paycheck. You're going to receive your P45 on this date, and everything is very clear cut for everybody involved. There's no, you know, grey areas, because it all does have to be set out rather clearly in the agreement. The confidentiality and gagging clauses, again, brilliant for a lot of employers that are concerned about reputational damage. If anyone gets pulled through an employment tribunal, that does then become public record. And that I know can be a major concern for a lot of clients. So this will ensure that that is not the case, and that it doesn't have to go anywhere for anybody to see. It's excellent with voluntary redundancy. So voluntary redundancy is always a difficult one because a lot of employers think, oh, well, we've offered voluntary redundancy and they've accepted it. So clearly they want to go. They're not going to pursue any claims against us. You know, it's all amicable. Everybody's friends until everybody's not friends anymore. And if there's no agreement there and you have just paid a random sum of money, probably more than what the statutory redundancy payment would be to an ex-employee with no paperwork behind it, it can all just get a little bit messy. So with voluntary redundancy, we would always recommend that there is a settlement agreement in place to facilitate that redundancy. It avoids processes such as grievance, disciplinary, redundancy and performance. So as I said earlier, with the 5 fair reasons to dismiss, a lot of those are lengthy processes. Capability, for example, as I say, can take a number of months to continue sickness absence. It can cut that right down. It can make sure that it's all wrapped up rather neatly, as I say, in one document, and it isn't going to be a long drawn out process where there are potential pitfalls. We cannot guarantee exactly how that process will go because we're dependent upon somebody that we don't know and how they're going to react. So it can definitely avoid those issues. Similarly, with grievances, we can include clause in settlement agreements that say your grievance will be considered withdrawn, it won't be looked into. If you have a serial complainer, for want of a better word, we've had a number of clients where there's been a grievance after grievance after grievance after grievance submitted, and it is exhausting and it takes up a lot of time and a lot of money to deal with. So this can also be a good way to nip that in the bud, and as I say, rather permanent full stop on the end of that. It can end relationships amicably. Not all settlement agreements come about because 2 people have fallen out. Sometimes it is just, this is a rubbish situation. And unfortunately, I do think we are going to see more of these as time goes on now, because it's not just the employees that have got bills to pay, it's the employers that also have bills to pay, and it's not great for everybody. So I think we will see a number of situations whereby it's just not going to work anymore, and you wish that other person well, they've done a lot for your business and you don't want to see them walk away with nothing. So it can then end those relationships quite amicably. Again, it's all tied up, it's all lovely, you've got peace of mind, they're walking away happy with a bit more than they would have done otherwise, and everyone's a bit of a winner. You know, it's not a great situation, but it's better than it may have been otherwise. So when can we not use a settlement agreement? So as I say, it does end most claims that can potentially be made, but there are other things that employees are allowed to do, and there is no way we can contract out of that right. So for example, you must always allow an employee to discuss matters with regulatory bodies, with the police, report criminal offences, discuss it with their lawyers, medical professionals, anyone else that's bound by an obligation of confidentiality. That is something that is allowed to be discussed, what the contents of that settlement agreement. Protected disclosures, so as I say, whistleblowing. If they need to report something to the HSE, if they need to report something to the police, if they need to report something to their regulatory body, the CQC, there is nothing we can do to contract out of that, and that is an absolute right that everybody has. So do bear that in mind if that is something that you're considering trying to prevent with a settlement agreement. Even if you've got the clause in there, it won't mean anything. They will always have the right to do that. Pension claims, it's always written in settlement agreements that you have the right to pursue claims if your pension has been incorrectly paid. That obviously may come about many years later when somebody goes to draw their pension and realises what's been happening. PI claims that they are not aware of at the time of signature, you can prevent claims being brought for current PI claims or PI claims that they're currently threatening. But say, for example, asbestosis was a common one, unfortunately, that you did not become aware of until many years later down the line, and it was deemed that it wouldn't be fair to prevent somebody from pursuing a claim of that nature because they could not possibly have known that that would be a claim at the time of signing the agreement. And claims to enforce the agreement. So if one party reneges on their agreement, if you don't pay what you've promised to pay them, they can enforce that agreement. And again, that doesn't necessarily have to be written in there, and it's not going to be something that you can prevent them from doing, because that's the whole point. The whole point of the agreement is that you're going to pay them some money and they're going to go away quietly. So yes, those are the main issues with what cannot be used with settlements. So just to go into a little bit more detail on whistleblowing, which I vaguely mentioned with protected disclosures. So we cannot, again, I can't stress this enough, we cannot prevent people from whistleblowing just by signing a settlement agreement. So the main, what they call qualifying disclosures, would be reporting a criminal offence, a breach of a legal obligation, a miscarriage of justice, a danger to health and safety, damage to the environment, or the deliberate concealment of any of the above. So if you have somebody who is threatening, as I say, to report you to the HSE for a huge breach of health and safety, and you think, oh, I need to make this go away, I can't be dealing with this claim, let's offer them a settlement agreement and you know, hope they sign it. That's not going to work. It's not going to be enough, unfortunately, because of the statutory right to blow the whistle. If you do need any kind of specific advice around whistleblowing, it is quite a complex area, so I would recommend getting in touch with us after this webinar, and we can obviously have a chat with you about that. But it's not kind of a straightforward, we can talk you through whistleblowing in 2 seconds flat type of situation. So we wanted everybody to have a bit of a go of thinking about what they would do with a settlement agreement and whether they can recognise when would be suitable to have a settlement agreement. So we're going to put everybody into some breakout rooms, which I think Lindsay might be able to do. But I'll just talk you through the scenario. So we've got a member of staff with 7 years service who's been off sick for 5 months with work-related stress. Before they went off sick, you were planning on starting a disciplinary process. You were unsure whether that you'd have enough evidence to dismiss. You know, they've got quite a lengthy year's service. It's probably going to be a bit of a process to go through, but nevertheless, they've been off sick now for 5 months. So you've been following your sickness absence policy, and they've been supplying fit notes to confirm their reasons for absence, but they have refused to attend any welfare meetings or discuss anything with you. So you've not really been in touch with them much. You can't see how they can return to work anytime soon, but this may not be sustainable for the business. So the 2 questions we want you to answer or discuss, at least in your groups, is do you think this is a suitable situation to offer a settlement agreement? And if so, how would you go about this and what factors would you need to consider? So have a look again at the scenario. I think everyone in a breakout room should have one of us from Bhayani, so we can talk you through it if you think that's a lot of information. Yeah. And then we can come back in 5 minutes, I think.
Yeah, well, I've allocated 10, so we can have a see. But yeah, so I think, let's have a look. Oh, we always see dropouts just before breakout rooms. Everyone gets scared.
Run away.
Well, you should know by now, if you come in on wheels, it's going to be a bit more interactive. So Hannah, you're in room 1. We've got Blythe in room 2. Nikita's in room 3, and I will join room 4. So I'm going to open those rooms up now. As I said, we'll be able to talk you through the scenario again, so don't worry, but I'll open the rooms now. We've got 10 minutes to have a chat and also to introduce yourself as well. So take this opportunity just to see who else is on. You might meet someone new.
recorded.
Everybody back in, Linz? Can you see? I think you're on mute, Lindsay.
I'm indeed. Yeah, we've just got one, sorry. That is, she'll find a way back. She'll be fine. She should be back in 10
We're
seconds.
lost in the abyss.
I can't pull her back. Can't pull her back. She's just going to have to wait it out. Yeah, so we've no, that was really good. So I don't know how other groups went, but in my group particularly, that we had a really good chat about this. And if you don't mind, Hannah, I'll feedback first, and then I can rest my voice a little bit more.
You go.
Fading away. So things that we discussed in our group was, is this too soon? So is it too soon? We don't know enough about what's happening. Have we done enough to get them into meetings? Have we done all we can to try and reach out to them? And yeah, basically, have we got any other options at this point? But I know one of the points I raised was, yes, for some companies, this would be too soon. They've got more resources to be able to not only deal with this, but also to handle the absence. But I know lots of companies that we engage with would see a 5 months absence as they can't tolerate that absence any longer. So I think it's looking at the individual business to see exactly what they can and can't sustain, where's their breaking point with this, but also, do we have enough information at this point in order to go ahead? So that was the feedback from our room.
Thank you. Yeah, sounds like you had some good conversations. We also had some really good conversations. One of the questions that was raised that I've not considered was, has their sick pay expired? Are they still continuing with sick pay? And I thought that was kind of going down the line of, oh, we'll wait until it's expired. But no, it's more of an incentive situation. So is there an incentive if they're going to be on full pay during this sickness absence? Is there going to be an incentive at this point to be looking at a settlement agreement from the employee's perspective, which I think is probably something to consider. Obviously, different businesses will have different entitlements, and whether that's something that they need to look at. But also whether, when offering the settlement agreement, is that employee, if it is work-related stress that they're off with, is this, something they actually do really want? They can't come back to the business. They don't want to for their own well-being. So would it be in the best interest that, yes, it may be too soon, or yes, they may still be on full pay, but irrelevant of the compensation elements and the financial aspects for their own kind of mental health, if it's the work that's causing the stress? And then also that might raise questions around the business itself, and why that is causing stress. But nevertheless, that's a different matter for a different day. Who's next? I can see Blythe. What did you discuss in your group?
So we were very interactive. I have to admit, we had some very good discussions. It was lovely. But what we did have a chat about was potentially an occupational health referral at this stage, if sustainable, if we could do it, whether that would help find out any more further information that's not really been disclosed yet, see if there's any underlying disabilities, anything like that, and then kind of take it from there, really. But especially if there is, then to tread very carefully at this stage. Just to be very aware of what's going on and to just tread carefully.
Definitely disabilities, whether they would be qualifying under the Equality Act, 100% occupational health, I think it'd be great, definitely. Thank you very much. And Nikita?
Yes, so very similar to a lot of you in terms of the timing of it. Is it too soon? And like Lindsay said, it's knowing the type of businesses, whether they can sustain it. gauging a bit more about the background information. Do they have any indication what led to the work-related stress? Are there any protected characteristics there? And also, like Hannah said, the pay point of view as well, in terms of how much money are they receiving while they're off, and is it worth just putting that money aside now rather than letting it drag out and put that towards a settlement payment to get the issue gone, if there's very little chance of it improving in the near future. So seeing the benefit of that, and in terms of them not engaging with it, it's just to perhaps send a brief written communication to say that you'd like to have a protected conversation, and see if that sparks any interest if you do decide that's the way you want to go with it.
Thank you very much. Yes, I think we've all had some useful conversations. There was no other breakout, was there? There was only 4. Great. Perfect. So yes, have I got control again now, Lindsay? I do. What we would consider. So yes, risk of disability discrimination. I think most of us did discuss that. Have you considered an occupational health report? And could you safely dismiss under absence yet? So look at your own policies of your capability in your absence process, and potentially referring to occupational health, because if they do come back and support your position, then great. They may come back and look at some adjustments and say, actually, this person could return with these adjustments in place. And again, are those adjustments reasonable for your business? Is that something that the business can sustain? These are all things that need to be considered. How far did you get with your disciplinary? So that was a point of the scenario. You had already looked at beginning disciplinary proceedings before they had gone off sick. So can this be used as an alternative to create that dispute for the without prejudice chat? So I think our group did discuss a without prejudice conversation and needing that dispute, that crystallized dispute there, in order to make sure that it is a protected conversation. Without prejudice chat, they are 2 different things, but that's irrelevant. Face-to-face is preferable. So again, can you invite to another welfare meeting? Can they come in to discuss? Because that would be great. But if they do refuse to engage, it may be that you do have to send that letter, that without prejudice letter, formally, and then potentially follow it up with an agreement if they do respond to that. And if you are having a face-to-face meeting, are you prepared? Do you have a script? Do you know what you want to say? You do need to make sure that you are getting these conversations right, because otherwise, as I say, they may not be protected, and then could be used as evidence, which is not the point of them. Where will it be? Would it be quite intimidating for an employee to be welcomed back to the office after 5 months absence for a meeting that they probably know little about? And they are going to, potentially be quite defensive, probably have the backup about it. And it might not be the great setup for a conversation between the parties. And that's ideally what you're wanting. So maybe look at a mutual location. And what will you be discussing, and who will be there? Are they allowed to bring a companion with them? Is that something that you're happy to do? Are you going to have 3 directors of the business sat opposite this one employee? Definitely think about those things and how to convey what you're wanting to propose to them. Offer letter or letter with settlement agreement straight away. I think we discussed in our group especially whether it would be worth sending a letter to see if they would be interested first of all. And then potentially following it up with a settlement agreement. It may be that this employee quite well, and that they would be willing to listen, so it might be worth just sending the settlement agreement straight away. You've heard on the grapevine, they've spoken to some of their colleagues, however that's come about. Obviously we wouldn't advise that as best practice because of the confidentiality clauses in the settlement agreement, but these things happen, and in real life it may be something that you are aware of. So it's not an absolute no to send the offer letter with the settlement agreement straight away, but it may be best practice if you have got the time to send them separately. Timeframes. So as we said, is it worth, as Nikita's group pointed out, is it worth kind of putting that money that you would be spending through these weeks and potentially more months of absence to kind of get things drawn up sooner rather than later, rather than following this long drawn out process? What will that look like in terms of time and money for the business? So that was really, really great conversation from a lot of groups, I think. So how do we go about offering the settlement agreement? Stop before you've even, as soon as you think, oh, this might be settlement agreement time, stop and think about it. Put a plan in place first. These are some of the questions that you might want to consider before offering. So why would the situation benefit from a settlement agreement? Like we say, time, money, threat of litigation. Those are usually the three main ones. It may cost you a little bit more imminently with the settlement agreement, right now cost, but the future cost of going through the long process, potentially defending a claim in the employment tribunal, there's going to be pros and cons to both of those situations. So they definitely need to be weighed up. And I think what we can look at through that exercise, and I think what most groups came to the conclusion of, is it will depend on a case by case, business by business, employee by employee situation. It's not a one rule catches all type of conversation that's going to be had. So weigh up the cost of a settlement agreement versus following the process. As I say, there are going to be pros and cons on both of those sides. Do you have someone who is trained to have that conversation, or have you prepared a script? Obviously, if you want more information about what that conversation might look like, or you'd want somebody else to do it for you, we are always, available, given time constraints, to either put a script together to talk you through it, to look at having that conversation on your behalf, should that be necessary. So that might be something that you want to consider. Coming to webinars like this is always a really, really useful way of at least getting your head around what it's going to look like and how it might be best to approach it. So you're kind of in the right place, definitely, to start off. Would you like the agreement drafting in advance of the conversation or afterwards? So it may be that your business is very clear on what they're going to offer. They may have a little bit of scope in terms of the compensation figures when they're being negotiated, but in terms of the terms, you know what that's going to be. You can get it drawn up, you can have it in place, you can hand it to them at the meeting and say, look, these are the terms, this is what it is. It may be that the conversation is a bit more flexible and the negotiation is going to affect the terms or change what may be offered, and at which point you may want to draft the agreement afterwards. Once it has been agreed provisionally between the parties, okay, actually, yeah, we are going to offer a reference, and we might want to put in restricted covenants, those different types of things. So it may be worth kind of not doing your time over twice in terms of when that drafting needs to happen. But again, that's going to be a case-by-case business decision as to what you need. How is the employee likely to take it? Are they going to be so offended that you're looking at terminating their employment and that was never their intention and they're just having a bit of a rough time and they want to come back to work? Or do you think actually they don't want to come back? It's not something that the business can continue sustaining. It's going to be in everybody's best interest. So it's probably not going to be the hostile conversation that it may otherwise be. Those are the things that you definitely need to look at and weigh up in terms of your pros and cons. And do you have a backup plan? What if they say, no, forget it, we're done, I don't want to have this conversation anymore? What's your next steps? What are you going to do? You need a backup plan, because this is not something that can be forced. This is something that both parties need to agree to. So definitely consider your options when you are looking at having these conversations. So when is a good time? If we said earlier, it may have been a little bit too soon. When is not too soon? When is the perfect time? Again, case by case. Generally, if you're looking at a disciplinary process, it may be when the allegations first come about and you go, actually, we could really look at this individual being in serious trouble here, and all parties might want to prevent going down that process. So it could prevent a lengthy investigation. It could prevent reputational damage for the employee and potentially the employer, dependent upon the disciplinary and how things have gone about. It can be used before the disciplinary hearing or at the conclusion of the investigation. We've done all this investigation, this is what we've found. You can present that alongside a settlement agreement, and these are your options. We're either going to continue down to disciplinary and these are the potential outcomes, or this is your alternative. We could look at a settlement agreement. Again, they may be more amicable and more willing to look at a settlement agreement on those terms if there has been serious misconduct. It may be that they don't believe any of those allegations and they would not be willing to consider a settlement agreement at all at that point. And as I say, that is fine. As long as you have a backup, you need that backup. Redundancies and restructures, as I say, voluntary redundancy as part of the steps to avoid compulsory redundancies. It may be that, this is a business decision. We're looking at a full restructure. Unfortunately, times are getting tougher. And so voluntary redundancies might be what you're considering. And settlement agreements, as I said before, are a great way to facilitate that. So that might be something that you want to look into. It will avoid the long consultation process, especially if you're looking at redundancies en masse, if you're looking at a lot of different employees. When there's not enough time to fairly consult, again, when you're looking at mass redundancies, there are certain timeframes that have to be adhered to as part of the legislation. And if that's just not possible, a settlement agreement may mean that you don't necessarily have to tick that box. It's a little bit of a jump to the next stage. So where there's a redundancy situation, but a consultation may not guarantee you the desired outcome. So there have been times where employers may want to look at a redundancy situation that may not be as transparent as others, and therefore a settlement agreement might be something that you wish to consider if you know who it is that you will no longer wish to have in the business. So again, that might be something that you want to take advice on that particular situation. And a restructure, which may also result in an SOSR dismissal. So that's some other substantial reason. So it's not necessarily that they've done anything wrong, that there's any capability issues. It's some of the substantial reason is often a catch-all. Your job is just no longer there. There's not something, a specific reason, but unfortunately, it would be a termination situation. And again, it may be that you think actually they deserve a bit more than nothing and walking away without a job. And so if you are going to be paying any extra payments, we would always advise that they go in a settlement agreement, just so that it's clear why that money has been paid to that individual. Performance management. So again, prior to the formal process, if you know the cards are marked and you know which way it's going, there's no more training that can be offered. There's no more teaching that individual how to create a spreadsheet. There's only so many times you can have that conversation. Then, you know, a settlement agreement might be the way to do it. Again, if those other situations, if you've already considered the cost, time, benefit, and you think that it wouldn't be worth going through the process. Absence management. So when the employee is unlikely to return to work, again, it avoids the procedure. However, as we've said, disability discrimination, when you're looking at absence management, there are certain reasons for absence that we would not recommend pursuing as capability, as disciplinary of any of those issues. If you are uncertain and you think you might be on shaky ground, do just get in touch and we can have a chat about it. Because again, it's on a case-by-case basis. Certain illnesses or reasons for absence are automatically covered. If you have an employee undergoing cancer treatment, for example, they would be automatically covered as having a disability. And that's something that you need to be very aware of. If you have somebody in our case scenario, for example, with work-related stress, it will depend on the severity. It will depend upon the effect on their day-to-day activities. It will depend on a number of different things as to whether they would be covered or not. So it's always worth having the conversation with somebody who may know a little bit more, just to consider if this is something that you need to do. Grievances and general breakdowns. So there's a variety of different reasons that people just fall out. It may not be that they've done anything wrong. It may not be that, you know, their job's still there and they're probably all right at it, but you just don't get on anymore, and it is not conducive to an effective working relationship. There's a lot of disputes, often between senior members of staff, directors, managers. It may be that there's been a loss of trust and confidence because of a personal issue outside of work that's been brought into the workplace. It might not be enough to dismiss. But people just don't get on anymore. Humans aren't designed to get on with all other humans, and sometimes that's just the way it is in the workplace, and therefore a settlement agreement would be your best bet. There isn't enough of a reason, and if they have had a falling out, they probably won't think twice about pursuing a claim to the employment tribunal. So a settlement agreement can get that all tied up nicely, and everybody walks away, you know, feeling like they've got somewhere. So, as I briefly mentioned earlier, a protected conversation and a without prejudice conversation. So there is a difference between the two. So a protected conversation is held where there is no existing dispute. So it's not necessarily what we call a crystallized dispute. You've not started proceedings. You've not told them, we have an issue with what you are doing, with your absence, with your conduct, whatever that is. However, this only does apply to dismissal cases, not discrimination or breach of contract. So if you have a protected conversation, that falls through, no agreement's drawn up, they pursue a claim to the employment tribunal and they want to bring evidence of this conversation in, and you go, hang on a minute, that was protected. No, you can't discuss it. The inadmissibility only applies to when there's claims of dismissal, not discrimination claims. So if you've brought them in and said, we're having this conversation with you because of your absence, because of this protected characteristic, this disability that you have, then that's likely not to be covered as being protected. However, if there is an existing dispute, then that would be a without prejudice discussion. So this must be a genuine attempt to settle. You can't just be putting in the subject line of an email without prejudice and then just going ham and being awful to the other side. It must be a genuine attempt. There must be something there of a compromise between the parties, the reasons why you're wanting to draw up a settlement agreement between the two. So the crucial question would be whether in the course of negotiations, the parties contemplated or might reasonably have contemplated litigation if they could not have settled it. So, is it going that way? Are we looking that we're heading towards an employment tribunal? If one's already live, winner, you're clearly covered. However, if you think it might be the way that it's going, then a without prejudice conversation, if there is that dispute, would be ideal, as long as there is that genuine attempt to settle. You're not just using it to cover your back with emails that you don't want being pursued, being shown to the tribunal. So what would you offer? What are you trying to compensate for? Have you dismissed them? Could you look at what they would have received as a redundancy payment should you have made them redundant? How much money and time will it save in offering the settlement agreement if they were to accept it? The general rules of contract apply. So the first day at university doing your law degree, they will tell you for a binding contract, you have offer, acceptance and consideration. So consideration can be as little as £1. I'll give you £1 as consideration if you accept these terms of this contract. But there has to be something. Can't just be nothing, else there's no binding contract. So you'd also consider what the likely award is that they would be set to receive in the employment tribunal. If you would say, for example, right, I think if they pursued this and they didn't settle it, they'd be set to get £10,000. All right, I'll offer them £8,000, but it's going to save them a lot of money in pursuing the claim. If they're going to get legal advice, it's going to save a lot of time. They might be happy to accept that offer. Similarly, what's it going to cost you to defend the claim? If it's going to cost you £12,000 in legal fees to defend it to a final hearing, but they're willing to settle for £5,000, it's probably going to be worth settling for £5,000. I know it can often be more emotional than anything else because you think, I don't want to give you a penny, I've not done anything wrong, I really don't want to be paying this out. But commercially, it might be something that you need to consider as to whether it is, going to be worth it or not. You need to consider the tax status of the payments. So holidays, notice, pay, those are all taxable elements, and it needs to be specifically stated in the agreement that they are such. Compensation awards, to a degree, can be tax-free, but again, that will depend upon the specific circumstances of the payments, and no decent solicitor will allow a settlement agreement to go through that has dodgy tax clauses in there, because they could also potentially be liable. So you do really need to get those right. And if you were to get some advice or get somebody else draft it for you, then that would ensure that they are correct and everybody's going to be okay with HMRC. And are you prepared to negotiate? Have you gone in with the only offer that you're able to make, or is it worth looking at, a bracket of negotiations? So if you think, okay, I don't want to, but I'd be happy to settle for £5,000, it might be worth going in at £3,000. They're going to come back at £7,000. You can probably settle around £5,000. I think somebody once said a good settlement agreement means that both parties go away unhappy. It's not ideal that you're both unhappy, but there is a compromise made on both sides. It's not going to be a straightforward, this is my only option and we're done, I'm walking away, because then there's no room. You kind of need a little bit of wiggle room. The clauses that you can include. So there are many different clauses that you might wish to include. And again, this will depend upon the specific circumstances. why are you wanting to settle? Being the key question of why you want to include what you want to include. So the termination date, when they're going to leave, that would be key. The salary and contractual benefits to the termination date. Are you on sick pay? Are you on maternity? Are you working? Are you not going to work? Are you going to be on garden leave? All those different things that can be set out in the agreement. The notice or payment in lieu of notice. So how much notice are you entitled to, and are you going to work that notice? Termination payment, holidays, pension, what that reference might look like, what you're announcing to the other staff still within the business. Resignations of directors, share incentives. If somebody has shares, that needs to be drawn up in an agreement, else it can get tremendously messy. Similarly with restrictive covenants, if you want to ensure that somebody is not going to go to a competitor as soon as you've paid them to leave your business and take all your clients with them, restrictive covenants are likely to be something you want to include within the agreement. These have to be specifically drafted to your individual circumstances. So again, I would recommend getting advice on those clauses specifically. Confidentiality, great for everyone involved. It's not going to get out and messy with everyone else. No bad mouthing. So, you know, you can't say anything bad about us and we're not going to say anything bad about you, because if it hasn't ended well, that is a great possibility. What are we doing with property, company cars? Do they have a laptop? Do they have a key? Do they have a fob? A mobile phone? All these things need to be taken into consideration and can be drawn up within the agreement to ensure that everybody knows, once this is signed, exactly how we're going to move forward. And then what happens next? So once you made the offer of the agreement and they're considering it, decide if they're going to be working, or are they going to be put on paid leave whilst they consider it? Do you want them in the business whilst they're considering being paid to leave it, is essentially your question. Set a decision date. So ACAS advised 10 calendar days from the date that they've received the agreement to when they have to decide if they're accepting it or not, and get advice on that agreement. Now, that's not the law, but it would be something that we advise, and it is reasonable. You know, these might not be decisions that people can make overnight. It may be that you've already had these conversations, but by the time they're given the agreement to consider, you know, they've had a bit more time than that, so you may not want to allow for the full 10 days. The agreement must be signed by an independent legal advisor. The amount of times we have people coming back to our clients saying, oh, it's fine, I trust you, I don't need to get advice, I'll just sign it, don't worry about it. No, make them get advice. They have to get advice, else it is not a legally binding agreement. You need another solicitor to sign that off and say that they've advised them on it, because you don't want them coming back in 6 months' time and saying, oh, that's what that clause meant. Oh, I didn't know that. That's not what I agreed to. And it could kibosh the whole situation. The standard contribution used to be, for that advice of the independent solicitor, used to be about 250 plus VAT. It's definitely more like 350 to 500 now. I've not seen any less than 350 for a while. I think they've been disappearing. Just like everything else, the cost is going up. Prepare for negotiations and consider responses and amendments. If you are sending that to another solicitor, which you must, then that solicitor might be advising their client, that employee, actually, you're set to get a bit more here, or actually, that clause is a bit too much, or actually, you need to include this. So do be aware of that and prepare your responses accordingly. It does become binding when both parties sign the agreement. So whilst they're still in negotiations, do just be aware that it is not a binding agreement at that point. And make the agreed payments on time. If you are to breach that agreement, then, as I say, there's nothing we can do to stop them enforcing that agreement. And it would be considered a breach of contract if it is a legally binding contract at that point. So again, bear that in mind. Are there any questions? I know there was one in the chat box earlier that Lindsay kindly dealt with, but I'm not sure if anyone's got any more. If you want to turn your mic on or pop it in the chat box or just wave at me. That's fine.
No.
Really
While you're having a think, if you do, I'll
Hello.
go through. Oh, have we got someone?
Yes, I have. It's just a quick question about pay. Is there like a general or standard rule for calculating the payment?
How much that you would be paying somebody in the settlement agreement?
Yes, does it have like number of years of employment and you know how much they their salary is? Do we consider that?
Do you want to answer that, Linz, or shall I?
Yeah, I can do. It literally all depends on the individual circumstances. Depends on your bargaining position. Sometimes we will only offer notice because there is a strong disciplinary action going ahead, which we're quite confident would end in a gross misconduct. So in that case, notice only would be our starting point. But other dismissals, generally where they're a bit more middle ground, I always tend to do a comparison with what a redundancy figure would look like, or what, and the redundancy figure as well is akin to the unfair dismissal award in the tribunal. So I tend to see that as a good rule of thumb, because again, as I said, we advise on both. We draft them and we advise employees on them. And if I was getting one in for an employee and looking at that and thinking, well, if you stood your ground and they dismissed you, because actually they don't really have a full reason to dismiss you, then your unfair dismissal award would look like this. So that's what then I would be starting from and saying, right, I think we should be aiming for a minimum of this amount. And then you've got things to take into account, such as notice pay, holiday pay, all that can add up to a big overall figure, obviously making sure everything's taxed appropriately. But to answer your question more succinctly, no, there's no hard and fast rule. Employees ask me all the time, do you think this is a good deal? And it does depend on the individual circumstances and why it's being offered. Is that okay?
Yeah, thank you.
Cover?
We've had a question in the chat box from Sam. If someone was to badmouth or make comments whilst going through the settlement agreement, what would be the best approach?
So again, firstly, have you already told them not to say anything? So if you've already issued that warning, generally in our opening letters, we will say this is confidential, you're not to discuss it with anyone else, and even go as far as say that to do so may be disciplinary conduct. So if you have issued that warning, then potentially you can add on a disciplinary process to your issues, which could strengthen your bargaining position. If you haven't issued that warning and you haven't said you can't talk about this, then you're not in a stronger position. But if they are bad mouthing the company generally and not just talking about the settlement agreement, you've still got all your other rights in place, and you deal with them as you would with any employee that was speaking badly of the company. Potentially you will be looking at disciplinary action depending on what they've said, who they've said it to, and what the damage is. So again, we'd be considering all this, particularly if we were lowering an offer or making a low offer to start with. So again, it's ways in which that we can use to bargain. So I hope that answers that question for you. Right, any others? Okay, well, if you think of any more, the chat box will be open for a bit, because I've just got a few more slides to take you through. First and foremost, what's really important to us is that you give us some feedback on today. We are planning next year's events. We've got dates in, but we're particularly interested in topics. So you'll be sent out some feedback forms. Please fill them in. Let us know what you want us to be talking about. And also, if you've got time, a review is amazing. It's great for us to see what we're doing right, what we're not doing as well as what we could do, so we can improve, but also brings more people to our forums, which is if they see good reviews. So again, we'd really appreciate that time. In terms of future events, what we've got coming up, this is just a snapshot of next year. As I said, we've done the planning for next year. We just need to fill in all the details. So we've got our ongoing equality and diversity training, which you can join. The big one is our Bhayani Business Social at the end of this month. It is full, but if you want to come, let us know. We've got a waiting list. We are having people drop off. We are able to offer more places when that happens. So please do come and join us if you want to, but let us know, because as I said, it's a packed out event. And then our next HR exchange is in January. Again, it's online, it's free to attend, and we're covering dismissals outside of settlement agreements. We thought it followed on nicely, because obviously this is a nice, in some respects, a quick fix, but if we've got time, to go through the full procedures. It could save you some money in the long run. So we're going to go through more standard ways of dismissals at that point. And then we've got our Bhayani Law annual conference, which we're so excited about. It's going to be our first annual conference. As I said, it's at Kenwood Hall, 19th of April. It is £55 plus VAT, but you do get an amazing lunch thrown in there as well. And as I said, we're going to do our big annual update. So we'll be telling you about all the case law, all the great, well, I hope, great cases that have come in, and legislation changes. Things that you need to be concerned about particularly, but also we've got a well-being aspect to this. So I've got a great speaker lined up on menopause, which is something we haven't covered yet in the HR exchange, not in any detail. So we wanted to get someone writing for that. And we're also covering, we've got hopefully a speaker I'm securing today on domestic violence, and again, how that can impact the workplace and things that you can be looking out for as an employer. So we are going to be releasing tickets for the Bhayani Law conference shortly. I believe there's an early bird discount, so watch out for those emails coming and get yourself booked on early to save yourself some money on that. As I've said before, we're Skillbank approved, really proud of this. So if you do want to take us up on any of our training, you can get up, I think it's even up to 60% off your training costs. So please phone us, talk to us about that, have a look on the Skillsbank website. And then finally, Watertight, as I said, is our main product here. If you have liked what we've said, if you like how we advise our approaches, then this is what we do day in, day out for our clients. So Watertight is our, it becomes your external HR support. Our packages generally include unlimited advice, template letters. We can help you with those settlement agreements that you want. It all comes part of that. And we've even introduced a light package now that starts at £99 plus VAT per month. It is a bargain. So if you want more information on that, do let us know. We've got something for everyone now within our Watertight packages. As I said, we advise lots of different industries. Get on our website, look at what we do, look at our services, see how we can help you. But more importantly, if you're not sure, just give us a call. It's free to have a chat with us. If you phone me today, I'll sound quite croaky, but next week it'll be better, so it'll be fine. Also, you can sign up to our newsletter, which is how you are going to hear about all our amazing events coming up. It's how you're going to hear about new changes in legislation, new case law. So please use that QR code on there to sign up to our newsletter. But also you can find a sign up section on our website as well. So thank you very much for attending today. As I keep saying, get in touch. There's so many ways you can get in touch with us. Thank you again for coming. Please let us have feedback. Please tell us what you want to hear next time. And we hope to see you all again in January for our next HR exchange, but also to see some of you sooner at our other events. So goodbye, everyone. And let me just check, no final questions. We'll hover around just for a few moments, just in case anyone wants to grab us. But